Thanks to Bernd Vey, our team of translators, Martin Navoa, Jonathan Bernertz, Paula Brinkley, Aaron Saudet, and my co-author, Home Putske. Welcome to the new life on the cutting edge. We are in an age of ferment and fervent discussion of children's human rights. Not every single event goes our way, but make no mistake, the overall trend is we are winning. These are heady times marked by a number of heartening events, including the Council of Europe resolution and recommendation, positive legal developments in Germany that we'll get into in more detail soon, Finland and Sweden each moving toward passing a law banning circumcision. The three events I mentioned yesterday, Ron Goldman speaking at the Council of Europe discussion, John Geishecker on Al Jazeera, and even the debate in Charleston, South Carolina, where Peter Adler, Aubrey Taylor, Angel Terron, and I left the American Academy of Pediatrics unable to respond and basically conceding the debate to us. So, to my shock, because I didn't believe it, Bob Van Houw said, we know this stuff better than they do. I didn't believe it. Bob was right, I was wrong. 12 years after the issue was first raised at the United Nations by ARC, the UN Committee on the Rights of the Child has asked Israel to report regarding circumcision. Now, there's some not so good news too. The recent Finnish legal case in which religious circumcision was found to be legal, the German statute, of course, the Obama administration's recent suggestion that their advisor on anti-Semitism is going to work to maintain circumcision in Europe, and of course the European Union Religious Freedom Act, which astonishingly is having us telling Europe how to follow human rights. Norway's new law and Denmark's new guidelines, which are both more or less in line with a 2001 Swedish law that basically medicalized so-called religious circumcision. So in this new age of ferment, several civil precedents around the world have safeguarded the child's right to bodily integrity. Not always squarely addressing the issue in those terms, and this is not a straight line of cases, and Home Putske wanted me to clarify that, but nevertheless, there is a path, as we will see, that's leading us toward protection for genital integrity. In 2002 in Erlangen, Germany, the local court barred foster parents from consenting to any surgical procedure for religious reasons, emphasizing that any type of circumcision entails bodily harm. The Nuremberg Higher Regional Court confirmed this decision on appeal. In July that same year, the Frankenthal Germany District Court addressed a civil case in which a circumcision led to 2 skin transplants and hospitalization. The court held, quote, and all my quotes are, of course, quotes of the translation, the consent of parents to a medically non-indicated surgical procedure performed by a non-physician under non-sterile medical conditions is contrary to the best interests of the child and therefore constitutes a violation of the parent's duty of care and custody. We'll get to the duty of care and custody of the parents later because there's been confusion. Some people suggest there's a right to care and custody that allows the parents to overrule the child's rights and do what they want to on the child's body for their own interests. That is incorrect. It's not correct in the German law, and it's not the law anywhere. In October 2006, in the other known German criminal case, a 77-year-old Muslim circumciser of boys was held liable for aggravated battery after having circumcised boys on behalf of their parents in at least 7 cases. In September 2007, the Frankfurt am Main Civil Appeals Court found that the circumcision of an 11-year-old boy, without his approval but at the father's request, was an unlawful personal injury, for which the father may be liable to pay damages. The boy was found to be too young to be able to meaningfully consent. And we'll see when I talk about Finland much later that, again, the father was potentially held liable in that case by one of the 3 judges who was dissenting. So there's been a strain of cases, even in some of the cases that don't completely go our way, where we are winning a partial victory. That same year, 2007, a Dutch court also disallowed a circumcision for, quote, hygienic reasons, as not in the child's best interests. In Bolt versus Bolt, a little closer to home, the Oregon Supreme Court in January 2008 reversed the lower court's decisions in favor of, the lower court's decisions had been in favor of a converted Jewish father seeking a circumcision for his, by that point, 13-year-old son. The Oregon Supreme Court remanded, in other words, returned the case to the trial court for further proceedings and to determine what the boy's wishes were for himself. In October 2008, in a case that was remarkably difficult to even obtain, but Jonathan Friedman helped a lot with that, the Finnish Supreme Court ruled that a circumcision performed on a boy for religious reasons does not constitute an offense. The religious reasons were held to justify the circumcision, even if the boy can't express his own opinion. The decision is partly explained by some apparently bad lawyering, citing a European convention that was held to only apply to organ transplants, the Convention on Human Rights in Biomedicine. And unfortunately, we'll see bad lawyering returning later, too, in some of the other cases as partial explanation of some of the cases that we did not win in. So German developments, including the later law protecting the procedure, have replicated many issues we've seen here in the U.S. Familiar issues include distinguishing male genital cutting as nothing like female genital cutting, this desperate rush to protect so-called religious circumcision, which we saw leading to the German statute, and the dialectic between an appropriately foregrounded child and other improperly foregrounded entities such as parents and society. As we will see, these issues manifest themselves in some problems, some central fatal problems with the statute, 4 altogether. Let's review German's legal structure, the German legal structure just slightly. Many of the legal cases protecting intent rights emanate from Germany, as we're seeing, and the modern German constitution, known as the Grundgesetz, or Basic Law, was adopted in 1949, right after World War II, and introduced a new constitutional order in Germany. Seeking distance from the horrors of Nazism, the Basic Law drew deeply upon German tradition to found the legal order on moral and rational idealism after Immanuel Kant. Thus, the Basic Law is value-oriented, obliges the state to realize a set of objectively ordered principles rooted in justice and equality, which are designed to restore the centrality of humanity and thereby secure a stable democratic society on that basis. Clause 3 of Article 79 of the Grundgesetz, called the Eternity Clause, prohibits amendments that violate Article 1. The Basic Law and the German legal structure overall, despite the fact that it's not common law but rather civil law, bear striking similarities with the U.S. Constitution. Both charters lay out basic fundamental rights. Now, we focus in the U.S. more on entitlements, on human liberty. The German Constitution focuses more on human dignity and consciously references ideas in homage to Immanuel Kant's maxim to treat people always as an end and never as a means. A central focus of German rights is preservation of the integrity and security of a person. Amendment of the German Constitution is deliberately difficult, requiring a 2/3 supermajority of both houses of parliament. And barring such an amendment, no right to practice religion can justify infringing another person's rights, including a child's rights, to the smallest degree. So the June 2012 Cologne Appellate Court case declared that male circumcision for religious reasons causes bodily harm and constitutes criminal assault. The decision marked the first generally applicable legal decision on the merits that male circumcision, if not medically necessary, and even if performed properly and with the consent of the parents, is punishable as a criminal battery. The court held that doctors are liable for a criminal offense under the Non-Medical Practitioners Act, where the physical well-being and physical integrity of a person is seriously impaired. The court noted that circumcisions performed for religious reasons are not medically necessary, and that circumcision is permanently and irreparably changing the body of another person. Re-S Children 2004 in the UK agreed with this result. It's a different legal system, but basically the same outcome. Although not addressing the legality of circumcision on the merits, the UK court noted, and this time I do quote, literally, "Circumcision once done cannot be undone. As the child has not yet chosen a religion," again I quote, "it is not in his best interest to be circumcised at present." Franz provides a nuanced view of religion's role in culture. Religious traditions are an archive of a collective story of adaptation spanning thousands of years. In past times, they were adaptive social rules in the shape of normative myths and rituals. Their adaptation to new social realities and developing worldviews only happens slowly, but it does happen, and it will happen. So properly foregrounding the child patient and emphasizing the procedure's irreversibility, the Cologne court stressed that the boy had a right to make his own decision about his body and about his religious affiliation. Children's rights to bodily integrity, self-determination, and freedom from harm supersede any interest that parents may have as caretakers and based on their religious beliefs. The court reasoned it wouldn't be an unacceptable compromise to wait until the boy was of age to make a decision for himself whether he wanted to mark his body with his religion. The Cologne court disposed of the religious and parents' rights issues without much difficulty, fundamentally saying your freedom stops at the boundaries of another person's body. As Hertzberg explains it, you can practice your religion as you choose. But if a homeowner denies you entry, can you force entry to evangelize and explain to that homeowner how his soul can be saved, no matter how fervently you believe that you're right? Can you do that legally? And we know the answer to that is no. UK case law supports this decision again. Re-A Conjoined Twins in 2000 said, and I quote, "Every human being's right to life carries with it, as an intrinsic part of it, rights of bodily integrity and autonomy. The right to have one's own body whole and intact, and upon reaching an age of understanding to take decisions about one's body. In what can only be described as a response to a perceived crisis, in fact, it was named as a crisis explicitly by some people who were talking about it, the German legislature passed a statute purporting to overturn the decision. As Ralph Eschelbach of the Federal High Court notes in his remarkable statutory commentary, I've read a lot of statutory commentaries, and let me tell you, Ralph Eschelbach really comes right out and says what he thinks, and very clearly, and his work is awesome. The bill unconstitutionally contravenes the basic law by violating Article 2's protection of physical integrity, and also Article 1's protection of human dignity. Jaruschek also stressed human dignity. The German parliament can only amend its own laws, not the basic law, and the Cologne court was careful to base its decision on the basic law. Hertzberg provocatively argues that the law, quote, stands in direct contradiction to the child's fundamental right. It is therefore incompatible with the basic law and void. This in turn means an assault based on the German law would be based on an invalid license and therefore be unlawful. That's Hertzberg. As I mentioned earlier, the bill has 4 core problems. It violates equal protection, it's placed in custody law, not criminal law, it's legally and logically contradictory in trying to incorporate a reason for the procedure into the statute, and there's contradictions in how it discusses the practice of medicine because it authorizes medical practitioners and also non-medical practitioners to practice asserted medicine that isn't actually for the good of the patient. So the first serious problem, as Eschelbach notes, is the requirement of equal protection, and that's enshrined in Article 14 of the European Convention on Human Rights, Article 3 of the Basic Law, Article 2 of the International Covenant on Civil and Political Rights, which, by the way, the U.S. has also ratified, and Article 1 of the Convention on the Rights of the Child, as well as case law from the Federal Constitutional Court. Walter distills the problem, quote, the state deprives the most vulnerable people in a highly sensitive area of the right to physical integrity solely on the basis of their sex. This is new. The violation is even more intractable than it was when some of us met last year in Kiel, because just a few days after Kiel, on September 24th, 2013, there was a new German law passed, Section 226A of the Criminal Code, explicitly outlining all forms of female genital cutting, including ritual nicks that don't remove tissue, similar to those allowed by the American Academy of Pediatrics in 2010 for about a month. These 2 laws are strictly inconsistent. As we will see, a second fatal contradiction exists, given Germany also has a law against corporal punishment that was passed in 2000. So Article 24.3 of the UN Convention on the Rights of the Child commits states parties to, quote, take all effective and appropriate measures with a view to abolishing traditional practices prejudicial to the health of children. According to the explanations on health impairment in Article 223 of the German Penal Code, and as pointed out in 2011 by Zerler and by Schleihofer the same year, and also by Pefkin, male circumcision is a traditional practice that is harmful to the health of children. The article applies to children of both sexes and thus protects boys as well as girls from genital cutting. A second central problem with the legislation, pointed to by Eschelbach, Hertzberg, and Isensee, is that it is not a criminal law, as was of course done with the law making female genital cutting explicitly illegal, but rather, very oddly, it purports to allow circumcision by extending parental custody. Now let's think about the U.S. for a while. The U.S. has a few states in which there have been laws passed saying male circumcision is not ritual abuse. If a male practices male circumcision, he's not violating the law, he's not committing an assault. So you have to scratch your head and ask, well, without the law, then that must logically mean that, in fact, male circumcision would be ritual abuse and would be assault by the mohel. And a similar problem comes in here, because what was done with the statute was not to make an exception in penal law, but instead to alter the custody law, the civil law. So the impulse is understandable. It's uncomfortable to criminalize parents or ritual circumcisers. There's this lurking feeling that maybe the issue belongs to the friendlier realms of civil law. The problem is that under civil law, the parents have the right of consent, as we said earlier, only to advance the rights of the child. Allowing consent to a medically non-indicated operation under custody law is legally, ethically, and logically incoherent. Mandela makes an interesting point. The Bundestag's, the German parliament's selection of consent law, logically implies that circumcision violates physical integrity, just as the U.S. laws logically imply that those criminal laws are violated in the U.S., without the law, that is. There is no doubt, says Fisher's statutory commentary, that individual and collective freedom of religion have to take place within the state's legal system. From Article 4 of the Constitution, no claim can be deduced to practice religious beliefs by medically pointless and risky mutilations of other people. As Boyka and Diesner affirm, there is also a right to negative freedom of religion. Negative freedom of religion, in other words, the freedom to practice your religion without having it being impacted by things that are done to you, which is violated by religious circumcision or arguably by any circumcision. There are no 7-day-old Jews. Robbers. Constitution Article Constitution Article 6, Paragraph 2, and the Convention on the Rights of the Child, Article 14.2, allow parents the right to act in the interest of the child in the exercise of parental rights. The state is obliged to protect the interest of children, even against their own parents. Since that 2000 law against corporal punishment, it's become even clearer. Notes Hertzberg, there's been a relativization of physical integrity of children in this situation to advance parental rights. And parental rights don't actually exist, as Bob Van Hoo has told us. It's a myth. It's dead dogma. This is circumcision being justified not as an act of care for the child, but as an act of care for religion and tradition. We have two landmark cases in the U.S. that tell us we can't do that here either. In 1878, Reynolds versus U.S., the Supreme Court held that laws are made for the government of actions, and while they cannot interfere with mere religious belief and opinions, they may interfere with practices. 1944, Prince versus Massachusetts, just a few years before the current German legal system was instituted. The court ruled, the right to practice freedom, religion freely does not include liberty to expose the child to ill health or death. Parents may be free to become martyrs themselves, but they may not make martyrs of their children before they have reached the age of full and legal discretion when they can make the choice for themselves. Prince versus Massachusetts, 1944, United States Supreme Court. Your rights stop at the boundary of your child's body. No right of freedom can authorize a holder of rights to infringe the rights of another. To rule otherwise is to set what Hertzberg aptly calls the normative power of the factual against law, truth, and justice. The third central problem is the law's incoherent attempt to build into the definition of best interests an evaluation of the purpose of the procedure. Now, interestingly, they don't explain what the acceptable and unacceptable purposes are. Why not? They can't do it. The desire is evidently to have a certain latitude to allow for exceptional cases or for some imaginary compelling case where, okay, the boy was circumcised, but I don't know, the parents were extremely fervent believers, or I don't know what the thought was. Maybe they had no thought when they passed this law. It certainly doesn't lay out any specifics about what the purposes are supposed to be, so we basically don't know. Even the pro-circumcision authors, Fateh Moghadam in German, concede that it's untenable to say that religion is not being violated by the procedure, when Chief Rabbi Metzger in Germany, for example, has made it clear that one of the main intentions of the practice is to mark the child as a Jew. The motivation for the action of the parents, which remains largely unverifiable, is irrelevant for the legal assessment of the child's well-being. Hertzberg, there is no reason to let motivation play a role in the legal assessment of the act. Whether it's beating, which we already know is illegal, female genital mutilation, which we already know is illegal, or circumcision, which we already know is illegal. There is no reason to consider that maybe some of these motives give parents a right to beat, mutilate, or circumcise, which they wouldn't otherwise have. Scheinfeld and Merkel astutely point out yet another problem, number 4, the apparent permission of anesthetic administration by a mohel. But anesthetic administration under German law must be done by a physician. The German Pharmaceutical Act of 1976 is quite clear about this. So we have this completely untenable situation of a non-medical practitioner being authorized to practice medicine in direct violation of the statute. They try to clear it up by mentioning the Emla cream in some fuzzy way. Well, first of all, the Emla cream has been completely rejected as being adequate for use for circumcision in Germany. That happened shortly after the Parliament wrote the explanatory notes in which Emla was mentioned. Secondly, in addition to the problem with having mohels practicing anesthesia, which they can't do, you've got a problem even with physicians, because physicians are obliged to do good for the patient, to help the patient. And by definition, they're not doing that if they're practicing a non-medical procedure. So even physicians have a problem when they circumcise. And this is just insoluble. There's no way around this. The statute is fatally flawed, constitutionally flawed. Mandless agrees. He says, under the statute, the physician is allowed to act in a way that a good physician actually should not act. These 4 contradictions are inevitable results of attempting to legislatively authorize a cultural and religious procedure, masquerading as a medical procedure that is in fact, as the Cologne court correctly held, a criminal offense. Now, it is often suggested that the current worldwide debate on circumcision is an expression of growing anti-Semitism, anti-Islamic sentiment, or xenophobia. The truth, pointed out by Gert Van Dyke and many others, is that since the atrocities of World War II, there has been an increasing emphasis on human rights, combined with a growing awareness that children have the same fundamental human rights as adults. Jews and Muslims have to conform their behavior with the law. We're even seeing corporations being potentially held liable under human rights laws. I mean, these are new ideas. The boundaries are expanding. We're not stuck in the 1950s anymore, folks, and religion can adapt. Franz says religion can adapt, and religion will adapt, and has adapted already. There is no question of Germany permitting other practices that have thousands of years of tradition, such as rituals of human sacrifice or the flagellation of a child on Good Friday, or the fact that even the religious direction to circumcise includes circumcising the stranger in your house, circumcising your servants. Well, nobody seriously claims that you can do that anymore, and nobody tries it because they know what would happen. They're going to go to jail. The child must be foregrounded, not parents, not society, with respect to a decision affecting the child's body. The legislation may be open to challenge in the Federal Constitutional Court, most likely through a specific case in which the result hangs on the law's constitutionality. Statutory reversal is the other theoretically possible but unlikely avenue. To take the most likely scenario, the legislation is vulnerable if there's a specific case in Federal Constitutional Court for violating the same articles that the Cologne court cited in declaring non-therapeutic male circumcision unlawful. If the law were nevertheless to be declared constitutional by the Constitutional Court, an appeal would likely be made to the European Court of Human Rights, claiming that it violates the European Convention on Human Rights. Of course, Cologne did not mark the end of German legal decisions. In October 2013, as I flew home from Kiel, in Hamm, Germany, the Hamm court forbade a mother from having her 6-year-old son circumcised because of a risk of psychological damage. Hygienic benefits vaguely claimed by the mother were rejected by the court. The current German law is an act of desperation, flying in the face of the court's courageous holding. The legal principles enumerated in the Cologne appellate decision are sound. Putzke finds the law, I quote, a constitutionally adverse, alien element in our legal system. Hertzberg, a law that allows the harming of children is a foreign body in the organism of our legal system and may not stand and must be rejected. Isn't it high time in the 21st century that the, I say it outright, scandalous violation of children's basic rights finally ends? France, it is remarkable that the meticulousness and creativity invested in the discovery of alleged medical benefits of an early circumcision by far surpass the efforts to empathize with the fears and risks of the child. Against these recent successes, there was a recent Finnish Court of Appeal case handed down that is contrary to the German trend of cases and upheld religious circumcision. In June 2014, the Israeli High Court of Justice held that a father that was trying to enforce a religious circumcision could not do so, but it was decided on narrow grounds, as Aaron Sadeh will discuss. And unfortunately, some bad lawyering led to the court making a declaration that in fact courts do have the right to enforce a circumcision even over the desires of one parent. And it goes without saying, the child. So we're in an age of ferment. And why are we in an age of ferment? It's because of everybody in this room. It's because of people walking the street. It's because of people writing articles. It's because of people on the internet. That is why we are in this age. Our opponents have a problem. There aren't many of them. They have a number of problems. They're following a dying meme. Sorry, folks, but the internet exists and is probably not going down soon. Blind respect for authority is waning as people think for themselves. Time for us to seize the opportunity. We need to lay political groundwork, continue to change public views, then change the law. We don't want a premature judgment that goes the wrong way. Circumcision is the outlier. Outliers don't last indefinitely. Marital rape used to be totally cool, no longer is it. The same thing is going to happen with male circumcision. Momentary setbacks represent the death throes of an old mentality whose days are numbered. We have to be sure to lay the groundwork so we can make good law. Make no mistake, we will win. We need to save as many babies as possible in the next 10 to at most 20 years, because after that, circumcision will be over, will be a thing of the past. People will be scratching their heads wondering why we ever did this barbaric deed. Thank you.